Hi everyone, it's Khan Ristik and welcome back to Beyond the Front Door, a video series that's focused on local business owners and the value they bring to our community, as well as sharing valuable insights. And today we're here with Avanti the Elwis of HDH Legal. Avanti, welcome. And if you could just tell us a little bit about what you do.
Thanks, Khan. Thanks for the introduction. It's lovely to be here. I'm Avanti the Elwis. I'm the principal solicitor of HDH Legal. We are a Melbourne-based property and business law firm. What that means in a nutshell is that we help clients buy and sell properties and buy and sell businesses, and we also help them protect their assets through negotiated contracts and agreements like licenses, leases, franchise agreements, and other commercial agreements.
Fantastic. And what is a challenge for clients when they're looking to perhaps buy a home or sell a home?
A challenge might be, I would say, understanding the fine print. It's really understanding what your rights and obligations are. And I'll give you a very simple example. My first home buying clients sign a contract assuming that the seller has to disclose what's wrong with the property. They assume that the seller has to deliver the property in perfect condition. The seller has an obligation to professionally clean the property. The seller has an obligation to fix what's wrong with the property. You and I, as professionals in the industry, know the seller has none of those obligations unless it is specifically written in the contract. So what we find is clients would make assumptions and then sign the contract. And unfortunately, that results in costing them money, because if you have not checked what's wrong, and one of the appliances does not work, what that means practically is that the client has to buy another appliance after settlement. That's an additional cost to a first home buyer that they did not anticipate, and in a very expensive transaction. So just making those inquiries before you sign anything right at the start of the process would make sure that you're better informed, and more often than not protects you from incurring additional costs.
Yeah, that's a fantastic point you raised, because I know when we're selling properties, generally we're selling them as is, unless there is something in a special condition as otherwise. Whereas tenanted property, for example, when a tenant is vacating, there are certain things like presenting the property, how it was found, and cleaning and steam cleaning and things like that, where a vendor is not obligated to do, as you've said. So
yes,
it's very interesting.
It's also understanding what your obligations are, because on the other hand of the point, right, a seller who agrees to the terms of a buyer without understanding what the standard obligations are may agree to more than what they have to. Now, if you understand your rights, understand that you're not required to, let's say, fix the damage on the wall, but still choose to do that, that is a choice you've made with informed decision. So, and that's fine. There's no right answer or wrong answer. It's more you having the information that you require to make a better decision.
And let's talk a little bit about land and buying land which is coming up for either settlement, or someone that's wanting to sell land that maybe has not settled yet. If you could maybe take us through a couple of important steps. If someone is wanting to sell a land that hasn't settled, or if they're buying land, what are some things to look out for?
Okay. So what you're referring to specifically is called a nomination process. When a contract is signed between the seller, which is the registered owner of the property, and the buyer, who is the buyer listed in the contract. Now, if the buyer wants to change the buyer in the contract to somebody else by nominating another buyer, or even changing how it is to be structured, it could be, I was planning on buying it in my name, but I want to add my husband in. That's changing the contract. So a couple of things that you need to be aware of generally. The first is any change to the contract is a variation of contract, typically subject to the consent of the seller. The contract will often contain a special condition that says that a nomination is subject to the seller's consent, and therefore the seller may say no. It requires extra work from the seller's lawyer and your lawyer, and therefore there may be additional fees attached that you have to pay. There is also, in certain circumstances, additional stamp duty triggered due to a nomination process. So you must then make inquiries from the State Revenue Office. So again, we are coming back to that original position of ask the questions first before you change anything in the contract. If you are a seller, understand what the developers' requirements are. If you're dealing with a developer, typically if you nominate a property for above the original purchase price, there will be additional stamp duty triggered. So be aware that there will be additional costs if you are getting a benefit from that nomination. For the buyer, be aware that when you are signing a contract and taking on a property under nomination, you are agreeing to all the terms and conditions in the original contract. So what that means practically is that you should receive advice on the original contract and understand them, and make sure that you can meet the settlement timelines before you commit to the nomination.
Thank you, Avanti. That's very valuable advice. I'm sure the viewers will take a lot out of. And besides your conveyancing side of the business, there are other areas which you specialise in, and one of those is wills. So if you could maybe talk a little bit about the process of getting a will. So it might be someone that's whether you're younger or older, whether you have children or you don't have children. I think a will is something that is going to be beneficial to protect your assets and where they'll go in the future. So maybe if we could talk a little bit about that.
Sure. So in Victoria, the assets that you own will be distributed under a schedule that is published by the government if you have not made your will. And that schedule is published by the government based on your particular family profile. So for example, if it is a wife and children, the wife will get the first $100,000, and then the remaining estate will be divided 50% to the wife and 50% to the children. If there is no wife or children but you have parents, it will go 50-50 to your parents, etc. So it will depend on your family structure. The purpose of making the will is really to ensure that if your wishes are not aligned with the government published structure, that your wishes are considered when the assets are distributed. And so you consider a few different aspects. One is what is your asset portfolio. The second is how do you want your assets to be distributed. The third is who can potentially make a claim against your estate and how do you protect against those claims. The fourth is other considerations, like for example, if you have minor children, would you like to appoint guardians for those minor children? Would you like to make special gifts to, let's say, a niece or a nephew or a grandchild? Would you like to make a bequest to a charity, etc. So you can make other provisions in the will that are aligned with your wishes for your estate.
That's amazing advice. Thank you so much. So Avanti, are there any other areas within your business that you would like to let our viewers know about?
We assist clients with business transactions, predominantly buying and selling businesses, from little cafes, mum and dad cafes, to medical centers and dental practices and motels, all the way up to national brands like Ferguson Clare, Pizza Hut, Bridgestone, etc. So with that business transaction, they work very similarly to a property transaction in that the contract is set up to transfer the ownership from the seller to the buyer. And once the contract is signed, a number of steps, procedural and legal steps, need to be completed in order to effect the transfer of assets. But before we sign the contract, a number of due diligence checks and requirements should be looked into by both the buyer and the seller so that they protect their interests. For a seller, it means maximizing their profit and minimizing their risk. For a buyer, it means not getting into a deal that could cost them a lot of money in the future. So carrying out those due diligence checks right at the beginning, then negotiating and signing the best contract for you to get the outcome that you want to achieve with that transaction. And then once you have signed the contract, making sure that all the assets are transferred, all the debts are paid out, etc., so that the buyer gets a really smooth handover and a good transition from the seller to the buyer with minimum issues cropping up after the settlement.
A lot of golden advice there. Thank you so much. And I know that you're local to South Morang, Mernda area, but your services cover all of Victoria?
Yes, we can assist clients with buying and selling of properties and businesses anywhere in Victoria.
Fantastic. So from conveyancing to business transactional contract reviewing to wills, there's a lot of amazing advice there you have for clients. And thank you so much for being on the video today. So Avanti from HDH Legal, if anyone has any questions, feel free to reach out to Avanti direct.
Thanks, Khan. Thanks for the introduction. It was lovely to be here.
Thank you.